All right, many thanks, Ben and Linda. Like we're discussing today, the Security Amendments Bill, all the talk in town is focused around this. And the one day that people have had to interrogate this bill, some people in government saying that it's happened that way before in other countries like the United Kingdom and the US with the passing of the Patriot Act. But nonetheless, let's get into some of the issues that people have with it. To my extreme right, or to my immediate right rather, is Henry Maina from Article 19, and our security analyst Andrew Franklin on my extreme right as well. Thank you very much for joining us. Let's start with you, Henry. What do you think are the major issues for you with this Security Amendments Bill?
The amendment bill seeks to make changes on 24 laws, substantive changes on 24 laws, even though Honorable Kamama told us that there are minor changes they are making. Mm-hmm. There can't be 24 laws where you're making minor changes, including doing away with constitutional safeguards on things like security officers would require a court order before they intrude into your space.
Yeah.
So the main things are that the bill in itself seeks to bring back a clause on national security, which was defeated. If you all remember when we were passing the Constitution, mm-hmm. there were two words that were sneaked on Article 24 before the former president was given the Constitution for promulgation.
Yeah.
That was defeated. They seem to be bringing it back in a way that national security would be a standing limitation on all Bill of Rights. Mm-hmm. So that's one issue. The second issue is that while it seeks in one way to say it wants to deal with the issue of right to privacy by protecting women and other people from being
stripped and protecting their modesty, yes.
On one hand, that's what it's done, and it seems popular to that extent that it's bringing in a harsh sentence of 20 years. But on the other hand, it introduces 10 other provisions where your right to privacy will never be guaranteed. Mm-hmm. So because of a possibility that intelligence officers can intrude and technically get into your communication system, they are now thinking that it is feasible and okay for them to snoop onto your communications, for them to look at your letters, your email, without any regard. Not that they have any record that they are suspecting you of anything.
How about oversight with respect to the National Intelligence Security Act? It is the Director General who would give this order, especially with regard to covert operations. That's what the amendment says.
There isn't clarity on how the proposed security amendment law would think through civilian oversight. In fact, if you take the Director General giving that order, and you take the proposed disciplinary board, which is again made up of only security agencies, 5 people, 4 of them being from the 3 security agencies, mm-hmm. plus a person who is fit to be appointed a judge.
All right.
That tells you that we are going back into a process where the security agencies do not want civilian oversight.
Okay.
And they just want to run away with everything in the name of counterterrorism.
All right, Henry, I'll ask you to adjust your microphone so that we can listen to you properly. Andrew, what is the problem for you with respect, or is there anything positive from this in this omnibus?
Well, John Allen, I'm not here to offer just problems. I generally try to offer solutions.
Yeah.
And I was very pleased that you forwarded the PDF to me. It's 90 pages. Mm-hmm. It's a 90-page amendment to any number of bills ranging from the Penal Code to Public Order Act. Mm-hmm. There has been no justification for these amendments to date, as in how amending these various and sundry bills would have prevented or mitigated the massacres in Mandera.
All right.
Either the bus massacre or the quarry massacre. Okay. In no way do these amendments, these suggested changes, are they explained by how this would have somehow
had an
ensured
impact
or had a positive impact on how the National Police Service failed to react at Impekitoni and Hindi to actionable intelligence furnished by the National Intelligence Service.
Okay.
In other words,
Yeah.
I mean, we're all on some sort of script here where there are people in Parliament who are talking about we're going to swing into action, desperate times call for desperate measures, hopefully desperate measures that might work. I would suggest that we are in some ways fortunate to have the United States, the Central Intelligence Agency, revealed in a Senate report today, having in the aftermath of the World Trade Center terrorist attack, the positive aspect is we formed our security services in the United States, which had been falling all over each other.
Yeah.
Obviously, the negative aspect was this rush to torture. This mad rush, which apparently, despite, in addition to being morally repugnant and not the American way,
wasn't
apparently
effective.
was not at all effective. And in fact, it comes out that the case officers in the field, CIA officers in the field, were saying, let's go back to the old-fashioned way of interrogating people.
Yeah.
We don't need what you have us doing because it's not producing any actionable intelligence.
All right, let me just swing it over to Henry for that. That's a great point to pick it up from. Henry, just as you adjust your microphone, I'll just have to ask you to hold it as you speak. With respect to the respect of rights of the accused, is there something that you feel might need to be changed, especially in the Prevention of Terrorism Act? The remanding of a terror suspect changed from 90 days to 360?
This is one of the biggest challenges within this law, that we've not had any tangible cases that clearly tell us that they were terrorists who we could not remand following justifiable reasons proffered by Director of Public Prosecutions. But we want to, one, lengthen that period indefinitely, because you're saying that from the 90 days, the court may be allowed to extend that. So it's remand by court.
Yeah.
Without putting in extenuating circumstances that would require that extension. That in itself is against the Constitution, because the Constitution clearly spells out processes. And what I need to reiterate, I think people in the security sectors and some of the MPs tend to think that people in civil society are against security actors. No, we would like the country to be secure. It's paramount. But that's not the only thing that would secure this country. We need to think holistically without being excessively reactive. It is because of being reactive and not thinking strategically that these attacks continue to happen.
But in the introduction of the National Counterterrorism Center, there are provisions for the National Counterterrorism Center to handle issues such as de-radicalization of people who are on the brink of radicalization and fundamentalism. Are those not positive changes?
They are positive statements that are not well thought through, because the bill does not even define what radicalization is. So radicalization here is thought to be a concept that only has negative connotations.
Yeah.
You could radicalize people to become excessively Kenyan, and that would be positive. Those who fought for our liberation were radical enough to stand against certain injustices. So as a human rights person, I train people to be able to stand on their feet and say no to torture and say no to human rights violations. If you then called me somebody who's radicalizing those people, you would get away with it, because this proposed bill does not define what radicalization is. It is anything that the security agency might not think it works for them. And then they will label it radicalization and run away with it.
Okay, Andrew, as we wind up, what are the short-term solutions in terms of handling the security challenges that we have if the laws, as quite a number of people are saying, aren't going to help change much?
The very simple answer is to start enforcing and implementing the laws we already have on our books, which are perfectly good. Whether it's the National Police Service Act of 2011, whether it's the Kenya Defense Forces Act of 2012, the National Intelligence Service Act of 2012, and more importantly, just as importantly, the National Security Council Act of 2012, which would give us sort of a super counterterrorism center if we needed it. But in the very short term, instead of spending a lot of time trying to pass amendments to some 25, 34 laws, where nobody is saying which laws to date have failed us, by the way. Nobody has explained how the National Police Service Act of 2011 has failed us because we have not implemented it yet.
Speaking of which, I'll just have to chime in there, the change of the procedure of the appointment of the Inspector General. Right now, we don't have an IG, and this law proposes that the President would nominate the Inspector General and the National Assembly, then vet him, as opposed to a selection committee. Your thoughts, Andrew, and then Henry?
Well, I think that the President, if he can nominate him, fine, as long as the National Assembly takes its position, which is as a separate, co-equal branch of our government under the 2010 Constitution. And also that the IG retains security of tenure, so that once the President nominates a qualified, suitable individual, and that person is properly vetted and put in by the National Assembly or by Parliament, we get to live with him for 4 years or 5 years perhaps. So that person can actually change that disorganized agency to make it an effective modern policing service, which will then be able to, given the fact that we have paramilitary and the administration police, we have specialized commando units and the general service unit, we have a criminal investigation department, we have the regular police. In other words, we have all the four arms for internal security
that we need
right now. We don't need to give the Director General of NIS his own little army. The Kenya Defense Forces needs to be reconstituted up on the border, possibly withdrawn from Somalia to strike out against our external enemies.
All right. Okay, Henry, what are your final thoughts with respect to the change in procedure of the nomination of the Inspector General, and generally, what do you think are the short-term solutions in resolving insecurity in this country?
Short-term solutions in dealing with insecurity is for the National Security Council to sit, debate clearly, and understand what has been ailing the country. The truth is, it's not for the dearth of laws. It's not for lack of laws that we've been attacked. It is for lack of proper deployment of police officers. When you deploy rookies, people who've just cleared college, to areas that are highly volatile, and you have the best of your soldiers where you do not need them. That does not need any military strategist to know it is wrong. Junior officers who died in Baragoi, junior officers who've been killed in Kapedo, it means somebody is not just thinking about basics. So we need to get those basics right. The second thing, the President and the heads of each of these security agencies have to deal with corruption and malaise within their teams. The third thing is, as a country, we need to begin having a clear accountability of security agencies. To the extent that they are an end in themselves, we will not manage to deal with this issue. The more they begin to understand, like anybody else, they will be held to account, the more they will change. Going back into old tactics of torture and violation is not what is going to secure Kenya. America employed those, they failed. They are rethinking about their strategies. Their Patriot Law was about outsiders. It wasn't about Americans. Here we are trying to bring it so that we gag Kenyans. I want to say that I've read through that, including laws like Public Benefits Act that have not been operationalized. We are amending them, giving the CS an opportunity to classify public benefit organization. For what purpose are we getting our energy on the wrong side?
Okay, unfortunately, we can't continue with this debate, but it will be a subject to national debate tomorrow on the floor of the National Assembly. Henry Maina from the Article 19, thank you very much for joining us. As always, Andrew Franklin, thank you very much for joining us tonight.